Good afternoon. My name is Andrew Bluestein, and I'm chairman of Garfunkel Wild. Thank you for joining us for Florida Telehealth, what Florida and non-Florida practitioners need to know. Susan St. John's will be presenting. I just wanted to introduce her and the firm. Just know that the slides are the presentation is being recorded. And for everyone who registered, we will be sending you the slide deck a couple of days afterwards. So look forward to getting that from us. At the end of the presentation, we will have some question and answers. You can put them in at any time. The earlier you put them in, the better. And because it'll give us a chance to think about the answers. If you click on the Q&A button at the bottom of your screen, you can type it in. Do not worry, no one else can see it. But if you said your name, that would be helpful. Especially as if we run out of time, we can reach out to you afterwards to answer your question. Okay, so let's talk about Garfunkel Wild. So if we go to the next slide, our firm, if you've looked at our website, is a little different than other firms. We have we're approaching 90 lawyers now, and we only do one thing. And the thing that we do is healthcare. So our tagline is we're full service, one focus healthcare. We've been doing this for 40 years. We have 5 offices. Our newest one is in Florida. That's why we're very excited about putting on this presentation. And we handle all aspects of healthcare, physicians, hospitals, technology companies, private equity, anything that anyone would want. If they're doing healthcare, we can help them. We have a very active compliance program group and litigation and everything a normal firm can do, just with this singular focus. And that's why we were extremely happy when Susan St. John agreed to come to our firm. So we'll turn to the next slide. I will introduce Susan because if she has a fault, she does not like to brag, but she should brag. Her experience is incredible. She has spent over 30 years in the healthcare space, both as a healthcare financial consultant and Medicare auditor, as well as a lawyer. She brings a vast amount of healthcare M&A and regulatory experience. She does a lot as well on the licensing and discipline areas. And she is just a walking encyclopedia. And that is why we are extremely happy to have her at our firm and to have her agreed to present today about a very hot topic, telehealth in Florida. So with that, Susan, you have to come off mute and I leave it to you.
Thank you, Andrew. I really appreciate the introduction, and it was very kind. So telehealth in Florida, I'm going to go through just a short history of it. Prior to the enactment of the statute, which is section 456.47 Florida statutes, we had only a rule under standards of practice for physicians. That's all we had for telehealth, and it really wasn't very workable. So we had a committee that met for a few years to determine how telehealth should be implemented in the state of Florida. After so much time,
Susan,
we finally got a law.
Susan, you're going to want to move to the next slide. It didn't advance.
Thank you. So we finally got a law that was introduced in the 2019 legislative session and became law July 1, 2019. Again, it was a long fought process. And besides just physicians, it wraps into telehealth services many other practitioners. So let's just step through what this law is about. First of all, telehealth is very specifically defined in the statute, and it is electronic information and telehealth communications technology that are to support and promote access and care, education, public health, and healthcare administration. So most of you on here are really going to be wanting to know about how you provide care through telehealth, what it takes. In the state of Florida, currently it is a type of two-way audio video communication, synchronous or asynchronous being store and forward. You can use video conferencing or the internet, the store and forward imaging, streaming media, and the communications are either terrestrial or wireless, terrestrial being wires on the ground. Think of it like that. Telephone calls alone are not considered telehealth. Email messages are not telehealth, and neither are facsimiles in the state of Florida. You need to have more. Not only that, telephone conversations, chart review, electronic mail message, and fax, as I just said before, those are not telehealth in accordance with our statute. Now, a little thing that we're about to have, we are in legislative session again, and there is a proposed bill to allow for telephone alone, audio alone, to be included in the definition. So we're waiting to see how that shakes out. It's made it through one committee with all yay votes, and most of our practitioners are very hopeful that we're going to see that added to the definition. Various services can be provided via telehealth. You can do assessment, diagnosis, consults, treatment, patient monitoring, and other types of services that can be provided via telehealth. The thing you need to keep in mind when you are providing telehealth services is it a good idea? Should you provide that service via telehealth? Or do you really need to see the patient in person or have a colleague see the patient in person so that they have, adequate care that makes sense for the problem they're presenting? So that's a really important thing to keep in mind. If you think for one moment that I can't really adequately assess my patient via telehealth, don't do it. Get a colleague or yourself, if you're an licensed Florida healthcare practitioner who has an office, have the patient come in. For those of you who are out-of-state registrants, and you feel like you can't adequately assess the patient or diagnose the patient via telehealth, refer them to a local clinic or a local practitioner that you might know of so that they can get adequate care. Again, very important to remember. The one thing that's also very good for telehealth in the state of Florida, a telehealth encounter can establish the patient-practitioner relationship. In other words, that can be the first time you ever saw the patient was via telehealth. You didn't have a relationship with them before, and they connected with you either through your website, they made an appointment, but they've connected with you, and that can be your establishment of the patient-practitioner relationship. Can be the first time you saw them, and you can establish that relationship. The other thing you need to know is that telehealth in the state of Florida, as I mentioned before, it's not limited to just physicians. Prior to the law being implemented, it was only a rule for physicians, but it has opened up to a very vast majority of practitioners that are licensed through our Florida Department of Health. So you have almost all the physicians except for the homeopathic or naturopath physicians, physical therapy, occupational therapy, speech therapy, massage therapy, acupuncturists, dietitians, And the list goes on. It's a very broad allowance for practicing telehealth in the state of Florida. So that's one good thing to know. Not, again, not limited to just physicians or perhaps APRNs or PAs. It is pretty broad in scope. So becoming a telehealth provider, if you're licensed in Florida, that's pretty easy. You can just add it to your list of services. You're going to need proper telecommunications equipment so that you can communicate effectively with the patient. And you want to keep in mind that the communications equipment you're using is HIPAA compliant. So we'll go over that as a recap in a few minutes, but that is vital as if you're seeing them in the office. You have to maintain HIPAA compliance. Very quickly, some of the telecommunications that were allowed sort of during the public health emergency, although, and a lot of practitioners use them, were Skype and FaceTime. FaceTime is not HIPAA compliant. Skype most of the time is not. There may be a Skype model or product that you can buy that is. But if you're going to offer telehealth communications, you need a telehealth platform that is that has integrity to it, that has what you need, and assures you that it is HIPAA compliant. Most of the telehealth platforms that are on the market today are HIPAA compliant. They also come with some extra things. They may come with patient intake forms. They're going to come with instructions that you will provide to patients about using the technology, and so on. And those things, it's very important to vet your telehealth platform to make sure what you're using is going to comply with the law, is going to keep your patient information communications confidential, and is going to be adequate for the patient encounter. So again, at Florida licensed practitioners, not too hard to add it. It's just a matter of making sure you have technology that can support adequate communication and maintain your HIPAA compliance. You also want to have adequate record keeping, and we'll go over that in just a minute. So what if you're an out-of-state practitioner and you want to provide telehealth services in the state of Florida? It's actually not too hard to do that. There are some specific requirements. And I've given you a link on this next slide. You should be able to see a link that takes you to the application for an out-of-state licensed practitioner to become registered to provide telehealth services in the state of Florida. The application itself is not difficult. It doesn't have a fee associated with it, but it does require that you fill out certain information. And the information required follows what's required in the statute. One, you have a valid license that is unencumbered. You haven't had an issue in the last 5 years with your license and disciplinary proceedings. You're not under current investigation or discipline, and you've not had a license revoked in any state or jurisdiction. So you'll notice that the no disciplinary proceedings has a time frame of during the preceding 5 years. The others, not under current investigation or discipline, as we know, often when you're under current investigation, it's not open to the public. It's basically a private matter unless you end up with an administrative complaint because a Department of Health in your state has found probable cause to file a complaint against you. But even during that, so to speak, quiet or private period, you're still under investigation, and you would be ineligible to apply for registration to provide telehealth services in the state of Florida as an out-of-state licensee. The provision that you have not had license revoked in any state or jurisdiction has no time limit to it. So if you've had a revocation of your license somewhere else besides Florida, you cannot gain registration as a telehealth out-of-state licensee. You are going to have to maintain professional liability coverage, similar to what's required of a licensee in the state of Florida, but a little bit different. certain licensees are allowed to go bare, meaning they have to be able to pay claims up to a certain amount, basically out of their pocket, and don't have to carry liability insurance. That does not apply to the out-of-state licensees trying to register for telehealth. You either have to have medical malpractice in amounts that are required, as would be required of a practitioner here, or you have to have a letter of credit from a bank that provides so much coverage in the case you get sued. So that's something very important to know. You want to make sure that you have proper coverage, because you will come under the jurisdiction of Florida courts when you register to be a telehealth provider in the state of Florida. Your website for your office or for your practice has to include a hyperlink to the Department of Health's list of all out-of-state registrants. This is so when a patient is looking to find a telehealth provider, or let's say a patient is someone who's a seasonal resident here in Florida, and you want to make sure you can follow them while they're not in their state of normal residency, and you're their doctor or you're their practitioner. They have to have the ability to look and see if you have registered to be a telehealth provider in the state of Florida, and that's how they would do it. It needs to be made as simple as possible for the patient to verify that you are registered here. Another thing, and I've had questions about this come up, if you are not licensed here, but you're registered here to be a telehealth provider, you may not have a physical office here ever while you're not licensed here and only registered here. So you can't like do a block lease and try and see patients from time to time in person. You can't have a kiosk. It is truly all via telehealth where the patient is located. They're not traveling anywhere to see you other than where they want to be. And so that's an important thing to remember, because I've had that question come up, and we had to make sure that that practitioner did not do any type of lease or have any type of physical presence in the state of Florida. You cannot provide any in-person services in the state of Florida. Remember, you're not licensed here, but you are going to register to provide telehealth services here. The Department of Health will use the National Practitioners Data Bank to verify the information that you submit in your application, to make sure that, one, you've been truthful as to the information provided, particularly the discipline, and whether you've had any revocation or any reports to the National Practitioners Data Bank. So you also need to be able to, when you register, you have to have a registered agent in the state of Florida. We can serve as your registered agent. In fact, I serve as registered agent for a number of out-of-state licensees who have registered to provide telehealth services here. That's a must-have. It's part of the statute. And one other thing, when you look at this application, if for any reason or just because you are busy, we do have a group that can help you. Our Garfunkel health advisors can help you complete that application so that it takes some of the burden off of you and getting everything ready to submit to the Department of Health. The application can be submitted either via paper application or can be done directly online. As I mentioned before, out-of-state practitioners who are doing business in the state of Florida are subject to court's jurisdiction here. And so if you have a problem, one, your registered agent's going to be served, but you're also going to be served up in the state you're at. So that's allowable by this statute and also by our long-arm statute in the state of Florida. So that's kind of it in a nutshell as far as getting registered and what it takes to be registered as an out-of-state licensee. And we'll go on to the next discussion.
Susan, before you go on, somebody asked a
Pardon
question.
me?
Before you go on, somebody asked the question, which might pertain to before you go on, which is what does it mean to be a registered agent? Like what's the purpose and what is that? What is the law trying to do by making you have a registered agent?
So the purpose of the registered agent is to make sure if you have a civil complaint against you by usually a patient because they felt like something went wrong. The registered agent is to accept service of process in case you get sued. You will be served in your location in another state, but your registered agent will be served here. So the registered agent, just like services they provide for entities under Division of Corporations, same type of thing is that. It would be similar services. They're there to accept service of process. Sometimes you'll find out it won't necessarily be service of process, but you might get a letter from someone, and because they're not certain how to get it to you, they're going to send it to your registered agent. So that's the purpose. Registered agents have to have normal business hours, have to be available. And that's the other thing. A lot of people we know try to be their own registered agent, and they give an address. They usually use their home address, but they're at work all day. And that's not the duties of a registered agent. Registered agent has to be at the address they've listed, and they have to be available during reasonable hours of the work week.
Great. And one last question about that, because by the way, guys, keep the questions going, but there's no way we're gonna get to all of them. But if you're a practice and let's say I have 3 doctors who have been registered in the way you described, do they need one registered agent for the practice, or do they need 3? Can be the same person, obviously, but 3 different registered agents for each separate registration?
I think I understand what you're saying. Each separate registration application has to name a registered agent. It can be the same registered agent, but each out-of-state licensed practitioner who wants to register to provide telehealth services here must list a registered agent. So a practice itself does not apply to be a telehealth provider. It is the licensee that must apply. Now, a group practice may want certain of its practitioners to register in Florida, and others may not want to do it. Again, it's about the practitioner registering and how the group practice handles that, whether they pay for it or not, or pay for a consultant to help with it, because the license application doesn't demand a fee. That's really up to the group, but each registrant has to have a registered agent.
Great. Okay, so now some questions are coming in about controlled substances, which is an excellent segue for you to continue.
Yes. So we're gonna so hang on a second. Before we jump into controlled substances, I just wanted to point out that there are Department of Health standards that are applicable to all telehealth practitioners, whether you are licensed here or whether you're an out-of-state registrant. Medical records documentation. You need to note in your medical records documentation it was a telehealth encounter, and it needs to have the same integrity as if you'd seen the person in person, if you'd seen the patient in person. So you want to keep that in mind. No shortcuts, and make sure that you state that it was a telehealth visit. You have to adhere to the Florida Practice Act as an out-of-state registrant. Our licensees here, they have to do that as well. Out-of-state registrants also, the other burden an out-of-state registrant has is they have to adhere to their Practice Act. And I want to mention this a little bit further. This is kind of the number one place that practitioners start to get disciplined, is because they get a little confused thinking, well, all I have to do is conform to the Practice Act in the state of Florida. State of Florida, we can now see practitioners prescribe controlled substances, 3, 4, and 5 schedule. Some states you can't do that. And if you're licensed in that state and you can't do that in that state, you can't do it in Florida either, regardless of what the Florida law says, because you're going to violate your own Domiciliary Practice Act, and you don't want to do that. I actually had a client that happened to didn't understand that a certain scheduled drug in another state was classified at a higher schedule than it is in Florida, and ran into trouble over that. So we don't want to see that, because as you all know, if you're licensed in more than one state and you get trouble in one state, it gets reported to the next state. All of it gets reported to the National Practitioners Data Bank. Same thing if you're a registrant in Florida to be a telehealth provider. You got in trouble here under your registration, that's going to be reported to the state where you're licensed, is going to be reported to the National Practitioners Data Bank. So you want to be really careful about knowing what the Practice Act is in each of the states that may apply to you. You don't have to research a patient's medical history just because you're giving a telehealth visit. If your telehealth visit is robust enough and you can gather enough information from the patient themselves, you don't have to do extra research. And again, as I said before, that telehealth visit can establish the patient-practitioner relationship. Communications and patient records, confidentiality has to be maintained, and you must follow HIPAA. This is very, very important. And again, you want to make sure that platform you choose also is HIPAA compliant. Remember, FaceTime is not HIPAA compliant. So if anybody is using that, please go and find a telehealth platform and one that is HIPAA compliant. So now segueing into controlled substances. In the state of Florida, and effective July 1, 2022, telehealth practitioners who are DEA registered may prescribe controlled substances. Did I do that? Hold on a second. There we go. May prescribe controlled substances, Schedule 3, 4, and 5. And that scheduling is under Florida's law. So you need to, again, as we just mentioned, you got to check your law as well, because while you might be able to, let's say, prescribe testosterone via telehealth in the state of Florida because it's Schedule 3 in the state of Florida, if you're in a state where the state has determined it should be classified as Schedule 2, and you decide, well, I'm going to prescribe this in Florida, but you're a registrant here and licensed in the other state where it's not permitted, you've just violated your Practice Act, which is going to be problematic for you if that becomes known. And trust me, it usually does. So you don't want to do that. You've got to know the Practice Acts of each state that you provide services in, because you're going to be controlled by those. Prior to July 1, 2022, the controlled substance prescribing was limited to psychiatric disorders and treatment of hospital inpatients, hospice patients, and our nursing home residents. And that was for any of the controls. The new law opened up the Schedule 3, 4, and 5, so that those 4 requirements aren't necessary anymore. However, they are still necessary for Schedule 2 controlled substances. So it's important, again, to go through that statute 893.03 and look at how drugs are classified here under what schedule before you decide I can go ahead and do this. Compare it to what's happening in your state, because you don't want to run afoul of your laws. In Florida, an initial in-person patient encounter is not required, but it is required under federal law, except it hasn't been required during the public health emergency. That's been an exception. And the DEA has also allowed kind of cross-border or crossing state lines to be able to order prescriptions and controls for patients during the public health emergency. Public health emergency is going to terminate May 11th, 2023. And so what's going to happen when it terminates, you've got to look at what the law is under the federal government, DEA, and what's required. When we revert back, what's required is at least one in-person encounter during the 24 months before you start prescribing via telehealth. So that's really important to remember. While Florida doesn't require it right now, the DEA does. And folks who are prescribing particularly controlled substances have to be DEA registered. So, so you're going to have to comply with the federal law, and you're going to have to see somebody at least once within a 24 period before you start doing the controlled substance prescribing via telehealth. So the other thing is the DEA during the public health emergency allowed for cross-border crossing state lines and prescribing controls. That is also going to go away. So what normally happens with the federal law is you have to be registered in the state that the patient is in, who you're prescribing the medication for. So I've had this question come up. I actually have a licensee who's licensed in 4 states and does have offices in 2 states, does telehealth in the other 2 states. And this question came up during the public health emergency. During the public health emergency, he was okay to not be DEA registered in the other states. We called DEA and asked them specifically, and we were in the public health emergency. They told us that once the public health emergency ends, he's going to have to be DEA registered in the state where his patient is. DEA registration ties to an address, not an address in your primary state, but an address in each of the states you're licensed in and you want to prescribe in. That's a little bit hard to do. DEA has not yet caught up with telehealth. So hoping that as they develop the new rule, and there is a proposed rule out there, hoping as they develop that, they'll recognize that there's a registration requirement that is actually tied to a physical location. So for my client that had that question, for the 2 states where he has offices, he will have a DEA registration in each of those states tied to those physical addresses. He'll be okay. The other 2, he doesn't have a physical address. So it'd be running afoul of the federal law if he prescribed controls there. Now, as I just mentioned a minute ago, DEA is set to publish proposed rules. You can find the proposed rules online. It's embedded in one of the links we have at the end of this presentation. It is 61 pages long. It can be pretty sleep-worthy reading, but it's very important to understand it because it is finally supposed to do what the Support Act that was signed into law in 2018 by President Trump is supposed to do what that act told DEA to do, and that is to promulgate a rule that allowed for the special registration so the practitioner could prescribe controls without having to have an in-person patient encounter prior to being able to prescribe controls to patients via using telehealth. So that's something you really want to think about, and you really want to have a lot of knowledge about, because it's going to be a bit of a game changer. It's going to take a while for this rule to become law. Once it's published, there's a 30-day comment period. And by the way, if anybody wants to submit comments, we can help you with that. Most of the time we're seeing medical associations, APRN associations, and others who can prescribe controls want to submit comments, especially if the proposed rule really doesn't go far enough, or even if it goes too far. Currently, the proposed rule would allow to have certain, most all drugs prescribed via telehealth, but President Biden on Friday wants to limit certain drugs like the opioids and Adderall. He wants to limit their ability for prescribing via telehealth. We'll see how that shakes out. That's just something his administration has said that they want to limit. He's been criticized for that simply because it might hinder access to care. And oftentimes the people who need certain types of medications, the most vulnerable population, are ones that have a hard time going to in-person encounters. So we'll see how that shakes out, but I encourage you all to keep your eyes open. We'll try and post things on our website or send out client alerts or through LinkedIn so that we can help keep you guys informed. So that's something to look for. We're hoping it's going to be, what it was intended to be, is that you don't have to have that initial in-person encounter to be able to prescribe controlled substances. Okay, so telehealth services for Medicare beneficiaries. As you guys probably know, ahead of the public health emergency, it was very limited. There had to be the originating site and a destination site. The originating site was not the patient's home. That's changed a bit. We know that a lot of Medicare managed care allows for a patient's home to be the originating site, and that's going to stay the case. And a lot of that flexibility we had from the public health emergency, Medicare is extending, and they may make permanent. But once a public health emergency ends, there should be an extension period to allow for a transition back to what the law provided, and also to allow for Medicare to promulgate some laws or rules that will allow the flexibilities we saw during the public health emergency to continue forward. So that's what we're hoping to see. We do know that certain telehealth services are continuing forward. They are still, they've been included in the physician's fee schedule, which is easy to access online. And I believe we've included a link in in one of our final slides so that you can look at that and see what to expect. There are going to be certain things that are going away. The virtual visits, they're going to go away, but you're going to have certain things that stay in place. We anticipate originating sites going to come back to some extent, and so be prepared for that. So for a Medicare fee for service, you might not see the ability for that patient to receive telehealth services at their home. We're just going to have to watch and wait and see. And we're pretty close to the end. I've included some useful websites in the back. The telehealth source for Florida, which will let you see what is required here to be a registrant in the state of Florida. Included a website for the DEA proposed rules. And again, I think most people are going to be pretty happy with those if we can get them promulgated, and if they are sufficient enough to allow continued greater access to care for patients, particularly our vulnerable populations. And then I've included Medicare policies during COVID so that you can remember what those are. And a lot of those are going to go away, but some of them are going to continue, and we're just kind of waiting to see. But they're also going to continue past May 11th for a certain amount of time. The publication I read said 51 days that they would continue, but as we know, that's always subject to change. So keep your eye on that. And then, one other thing, uncontrolled substance is very important. And I think almost everybody does. They know they have to do it. You've got to, when you're prescribing a controlled substance, whether it's through telehealth or in-person encounter, you've got to use the prescription drug monitoring program to look up what that patient's history is. In Florida, it's called eForce. So our out-of-state licensees who register here are going to have to be able to use that, because you're going to have to be able to look up that patient on eForce, because it could be that you're not just following patients that are domiciled in the state you're licensed in. You're going to be able to serve patients in Florida, whether they're a patient of yours in another state or not. So if they are here, you still are going to have to use e-force because that's a requirement when prescribing controlled substances here in the state of Florida. So again, very important. You want to be able to put in your medical records that you've looked at the e-force and have noted you're going to note what prescriptions this patient is on, what controls. This is to help stem abuse of controlled substances or overload of certain types of controlled substances. Whereas, like, so you might have one doctor who is prescribed for non-acute pain, but then you have another doctor who prescribes because someone's had an injury and they have acute pain. You've got to be able to look those up and see, are those compatible? What's the overall formulary and amount of the narcotic that the patient may be consuming? If they have to have an additional medication added, you need to be able to know what drugs play nice together and what ones are going to be too much or might overload a patient's system. So very important to look at that information. Again, that's another, it's another place that practitioners get in trouble is they're not reviewing that particular database and thoroughly, and they have to. That's a requirement. So there are other requirements under the state of Florida for controlled substances. It is always a good idea to have an agreement with the patient, a patient agreement for use of controlled substances to make sure the patient understands what their responsibilities are, what you expect of them, and what they expect of you. Very important. That is a requirement for prescription of non-acute pain narcotics. It's not required for all controlled substances, but it is a good idea.
Okay, so now we can move to the question and answer period. We have a lot of questions, and some questions came in even before the webinar. We're not going to get to everyone. Also, some of them are very specific to your practice. You could feel free to call us, but I think this is really an educational seminar, not necessarily legal advice. So maybe, Susan, if you want to go to your contact information while I go to the questions. One of question, Susan, I actually am going to ask, when you mentioned e-force, I have a client where the patient was treated in New York, then went to Florida, and actually in Florida had a telemedicine visit, checked e-force, but didn't check the New York corresponding e-force kind of thing. It's run by a different name here. And I'm having a regulator right now say, well, you should have checked both. Even if not required, I wonder if you could speak to whether it's just good practice if you're treating somebody in one state and they leave, maybe they got a prescription and then they got on a plane and went down there. You might want to check both. What do you think about that?
I think you actually have to check both because the state that you're licensed in, you have to follow the laws of the state you're licensed in. And it's a prescription drug monitoring program up in that state requires you to check their database, check the patient's name in that database, then you need to do it. I mean, it could be that, the patient may not be entered in there because they've never gotten controls in another state. But they, for the first time, are getting their controls in Florida. So they're going to end up on the Florida e-force, but I think the regulator is not incorrect. And again, I have a pretty good relationship with Department of Health, and they said that's almost always an I gotcha moment for a practitioner is thinking, well, I have complied with the laws in the state of Florida, but they have to look at what the laws are in their state.
Right.
Of
Sure.
licensure.
We've gotten a couple of questions about specific codes you could use, or what codes could be recommended for telemedicine billing. What I would say is, again, that's one of those things that's awfully specific. But if you give us a call, our subsidiary that Susan mentioned, Garfunkel Health Advisors, does coding and registrations, like Susan said. But those people, you working with Garfunkel Wild attorneys, can help you figure out what the best code is for your practice and for your patients. So Susan, next one. People are asking about the type of medical records that they should keep. I have found, and I would wonder your thoughts on this. People somehow often feel that if it's telemedicine visit, I don't need to chart it as extensively as I would in a face-to-face environment. Could you speak to that?
Absolutely. So the notes and charting that you put in your medical records, um, it would be the same as if you did an in-person encounter. You need to put this same robustness you would as an in-person encounter. So you do an assessment of the patient, write it all down. You make a diagnosis, you write it down. You come up with a care plan, you write it down. You order labs, you write all of it down. You write all of the complaints the patient has, write them all down. It's not a place to skimp just because you're able to provide telehealth services. It has to be as robust as if you are in person. But you do want to add, this was a telehealth visit, because you want that noted in your record for yourself. And that's not because, someone's looking for you to miss something because it's a telehealth visit. It's just part of your record. Just like when they come into the office, now that we have telehealth and in-person, probably not a bad idea to write down in-person visit. Again, it's just additional information in your medical record.
Okay, good. So we got a lot of questions about platforms and how do you make sure they're HIPAA compliant. My view, I don't know if you share this, my view is that OCR has taken the position that they won't specifically say this is HIPAA compliant, and people use that phrase as a marketing tool more than anything. And the way to protect yourself, I would think, is let them say whatever they want, but you really have to review an agreement and make sure you have the right reps. And I know a great law firm that reviews those agreements, but Susan, what are your thoughts?
I agree, 100%. I mean, that's kind of where the rubber meets the road. They'll demonstrate a platform to you, and they can, tell you that it's HIPAA compliant, but it's really hard to show someone proof positive it is HIPAA compliant almost with any type of the systems. But you're looking for the safeguards. How do you access? Can anyone else access? Having security passcodes, and limiting the number of people that can use the platform for those who need to use the platform or who will actually be serving patients on the platform. So those are kind of the same thing you would want, just like you have in your office. Not everyone gets access to patient records. So you want to make sure that your telehealth platform has the same safeguards, because not everyone gets access to the telehealth platform. It's going to be the practitioner serving that patient. And so that's important. Yes, you want to look at the contract, and you really want a robust contract. You don't want a 2-page contract because it's probably not going to protect you enough. You want to make sure you have a business associate agreement. But the representations and warranties by the telehealth platform provider they're fundamental. You have to have very strong reps and warranties.
Yeah, and we've had more than one telemedicine platform that has taken the position that they won't sign a BAA. I would say walk away, run away is really what I would say.
I would agree.
Yeah. Okay. We're getting questions about, and I know this is about Florida, but I know you have a lot of knowledge. Garfunkel Wild has helped people do this all over the country. Can you speak to the general rule is, do I need licenses now outside of Florida, in other states generally, and how does that work I'm sitting in X state and my patient is in Y state. What's the general rule, and can you speak to that?
General rules, you have to be licensed in the state where the patient is located that you're going to provide services to. That's the general rule. There are some states that have exceptions, and there are some states that have limited licenses. There's some states that are part of a compact, like a nursing compact or a physician compact, where you can get licensing in multiple states. But generally, Florida is the exception. We allow registration. You don't have to be licensed here to provide telehealth services. Most states, I've looked at about 6 states, most states require you to have a license. There may be a state that, and I don't want to misstate which state it is, but there is a state that allows a practitioner to provide telehealth services in that state when the patient is there for, let's say, an extended period of time, as long as the practitioner, who's not licensed in that state, has seen the patient in person in the last year. And it can be a rolling 12 months. So there you might find an exception like that, but generally the states are going to hold that you have to be licensed there.
Yeah, and what I would say is also, and this might sound self-serving, but we have many national providers who are always updating our research. These rules are constantly changing. So if you get on the internet and you pull down a survey for free and you thought, well, that's good, now I don't have to pay a lawyer, I get it, but it literally could change on a month-to-month basis. So be careful about what you rely on. Okay, I know we're definitely running out. We're running out of time, so let me move along. The issue of malpractice. And I know you're not a malpractice attorney, but you touched on it earlier. And it's really more of a medical question. But do you see in the future, as telemedicine is becoming so popular, that there may be a criticism of a doctor where he should have sent somebody for a physical exam and not relied on telemedicine, and that may have led to a bad outcome?
Yes, I think we're already having that now. Especially, there's always somebody who's unscrupulous, not necessarily the practitioner, but maybe who the practitioner works for and the way they demand that practitioner work. And it's the practitioner's source of income. It may be their only source of income. So I've actually seen that already. I had a disciplinary case where the patients needed to be seen in person, and all of it was handled over telehealth. And it was not just 1 or 2 patients; it was quite a few. So there was that, and really besides the patients being unhappy, because that is what got the practitioner targeted, the payer became very unhappy, and the payer is the one who actually did the complaint to Department of Health, and didn't just complain once. They called Department of Health every week, hoping to get that practitioner disciplined, because they felt like it was the wrong mode of encounter for those patients. So you really have to be careful with that. I mean, it's not just going to be a malpractice issue. If you have a malpractice issue, you are going to have a discipline issue. We avoided the civil malpractice issue completely. We actually avoided discipline as well. But that was, that's the exception, not what I normally see. So yes, I mean, is potential that you're going to have a patient that complains, and there are lots of malpractice lawyers in every state that'll take up that case. One of the things you can do to try and protect yourself is, when you are doing telehealth encounters and patients are wanting to do a telehealth encounter, they have to sign an agreement. A lot of the telehealth platform providers have the agreements embedded in the platform, so that when the patient registers to be a user of the platform, they are going to sign an understanding of what can be done through telehealth. And that, and then there are certain problems that a practitioner should be aware of. That's not appropriate to treat via telehealth. For example, Teladoc has a policy on certain types of chief complaints, that when you get on the visit with the Teladoc, and you tell them your chief complaint, they'll tell you it's our policy. We don't treat those via telehealth. You need to go into a clinic. And it's as simple as that. And if when you listen to a patient's chief complaint, or maybe you're listening to all the complaints and you realize this patient probably needs an in-person encounter, it is really the burden of the practitioner to make that call. It's almost always going to be burdened on the practitioner.
Sure. Okay. Thank you. I found it interesting. Hope everyone else did. And one last question, and then we'll wrap up with a final comment. Somebody asked, I know you said that, and I know we are submitting comments on the proposed rule for clients. If they wanted to do it themselves, how would they find out how to do that? I don't know if you know that off the top of your head.
Yeah, I mean, I actually do. So the link that I provided in DEA, it tells you that once the rule is published, that you can submit proposed comments and you can submit them online, and it should kind of walk you through it. It should have a hyperlink in it that will take you to what to do. When a proposed rule is published in the Federal Register, it tells you where you can submit comments or how to log in to submit comments. So that's just a matter of following and it's in the precatory language of the proposed rule that's been published, and it comes ahead of all the text of the proposed rule. It tells you how to submit comments. But if anyone has questions, just even about wanting to submit their own comments, we can help them and direct them to where they need to go, or just send them a link so that they can look at the proposed rule and then follow the instructions for submitting proposed comments.
Great. Okay. So remember, we'll be sending out this recording. Feel free to contact Susan. There's her email on the screen and her her office number. And you can also just search Garfunkel Wild, look at our new website, and find all the partners that are there and all the associates. And we can also hook you up with GHA if you need. I want to thank everyone, and thank you, Susan, for joining Garfunkel Wild, and we look forward to many more presentations on Florida-related topics. Have a great day.
Thank you so much.